Thank you very much, and thank you for inviting me, and thank you for organising this terrific forum. I've been asked to speak on sentencing, parole boards and changing laws for individuals, so I should be finished by about midnight, if that's all right. In fact, after listening to this morning's session, I should be speaking at the IPA functions rather than here, preaching to the converted, because I think there's certainly a different world view. But I'll do my best in the time and then leave time for questions. We've seen over the last decade and a half of this century major reforms to the criminal justice system in Victoria, and we've seen them around Australia. And they've had a significant effect on the prison population, which has increased rapidly and significantly. The interesting thing is that the exploding prison population can't be attributed to the traditional causes, namely increasing crime rates or changing demographics or broader social and economic pressures. Not much has changed there. Rather, it's the local political environment which has led to a more punitive approach to crime and justice. We've seen Conservative governments elected around Australia over the last few years. All bar one state, and South Australia only got in on a whisker, have espoused policies that have come to be regarded everywhere else in the world as too expensive, unnecessary and ineffective in jurisdictions that have pursued them for far too long. The prevailing political mantra is, we make no apology for those policies. And that mantra ignores the history of penal reform elsewhere, discounts the criminological evidence, and ironically, for policies founded on the idea of penal populism, only provides limited and ephemeral electoral support. So the combination of law and order campaigns, an increased emphasis on public opinion, and a belief in the value of prison as a response to offending has left Victoria with a rising prison population and enormous financial investment. Just by way of background, December 2012, our Australian prison population reached a record of 32,240 prisoners. The Australian imprisonment rate now stands at 180 per 100,000 of the adult population. Victoria, a little while ago, in fact in 2002, the imprisonment rate stood at 94.2 per 100,000 adults. By December 2014, this had risen to 129 per 100,000. We're climbing rapidly up the charts. If it makes you feel any better, the United States is 800 per 100,000, so they hold the world Olympic record for imprisoning people. And if it makes you feel any better at all, Northern Territory stands at 861 per 100,000. So we're not up in their league, but whether we should be aspiring to be there is another question. There's been enormous changes in the Victorian prison population. We've never seen such changes in recent history, and by that I mean over the last century. In fact, in 2012, in June, we had 4,884 prisoners. In June 2013, we had 5,340, and as of last Friday, yesterday, we had 6,037. You can see that the numbers are increasing. There's a new record almost every day. In Tuesday's state budget, you will have seen that the Department of Justice has forecast a target of between 6,400 and 6,900 beds, and they've committed $447 million for 871 new beds, with another 2,900 planned. In terms of your money, your taxpayers' money, it's expected to grow, the spending on prisons expected to grow from 746 million last year to 942 million. That's an extra 200 million odd just on prisons. So we've seen dramatic changes, and we're starting to see the fiscal cost of these policies. 2010, in a sense, marked a watershed when we changed governments. Previously, law and order had not featured heavily. It hadn't been invisible from campaigns in Victoria. We thought we were a very enlightened, a very rational society. But I think in the last week of the campaign, law and order really took hold, and the Coalition founded its campaign on the idea that Victorians were soft, We're tired of a soft on crime approach. New government would be tough on crime. Now, the Labor government was not innocent in this regard. In its years in office, although it had implemented a wide range of reforms, including drug courts, problem-oriented courts, family violence courts, the Neighbourhood Justice Centre, it didn't adopt a wholly moderate agenda. During its tenure, it changed the law significantly in terms of sexual offending. It introduced continuing detention and supervision of sex offenders. It introduced a register for sex offenders. It restricted the use of suspended sentences for serious crimes and enhanced the role of victims in the sentencing system. Despite these reforms, the coalition still painted the Labor government as being out of touch with community fears and demands that crime needed to be dealt with by getting tough. The campaign approach was indicative of three key values adopted by the party: the politicisation of crime, a reduced reliance on expert advice and evidence, and a firm belief in the effectiveness of prison as a crime control mechanism. And I think it's these values, together with some high-profile cases, especially the tragic Jill Meagher case, which have been the primary drivers of criminal policy in Victoria. Let me look at those very briefly. One is the politicisation of crime. Crime is always an issue somewhere in every campaign, but its salience tends to vary. At the time of the election, you may recall there was a huge debate relating to the level of crime, whether we could believe the police statistics, and there was some doubt about those. Ombudsman's reports and various other independent reports said they weren't being recorded properly. There was an election promise to establish an independent Bureau of Crime Statistics. I'm pleased to say a mere 4 years later, acting with alacrity, that's been established, and that's now underway and should start producing statistic, I think, early next year. You remember alcohol-fuelled violence in the Central Business District was also a major issue, and despite the fact that crime rates have been dropping for the last 20 years in Victoria and elsewhere, there's still the perception that crime is going up, fuelled very much by the tabloid media who make a feast of these unusual cases and whose prime task is to engender fear and anxiety in the community. As you know, we live in different universes. If you listen to the ABC and read the Fairfax Press, you can walk the streets safely and without great fear. If you watch a current affair and read the tabloid press, you'd be lucky to move out of your house without being raped, robbed, pillaged and maimed. I think that's really important in terms of setting up the atmosphere in which these particular policies occur. It's a bit like the manufactured budget crisis. If you can manufacture a crisis, then you can intervene in ways that aren't particularly effective or rational. In terms of privileging public opinion over expert evidence, there were declarations that criminal justice had been dominated by experts for too long and the public needed to be brought to the fore. To this end, you may recall the government commissioned a public opinion survey conducted with that wonderful independent research organisation, the Herald Sun. And the aim of the survey was to seek public opinion about the appropriate sentences for a range of offences and aggravating and mitigating factors. It was never explained how that opinion was used, and I never saw it used again, but it did create that atmosphere that the public, and of course the Herald Sun readers are a perfect cross-section of the community. You're aware of that. At the same time, our advisory council would thankfully, and I give the government great credit, I have a self-interest in it as chair of the Victorian Council, we weren't abolished as happened in Queensland about 2 or 3 weeks after the Newman government was elected. They got rid of their sentencing council, but ours has survived, and I have an excellent relationship with the attorney. But some of the findings of our research, for example, advice showing that deterrence does not work, imprisonment as a deterrent doesn't work generally, that incapacitation is not an effective or cost-effective strategy, and that in fact imprisonment is criminogenic, it creates more crime than it solves, were not well received by the government, but nonetheless we're still consulted and we still continue to produce our reports. The problem about privileging public opinion is twofold. One, that it's based on incorrect information, and when scientific information is put out, it's often denigrated. Secondly, politicians have a view of what the public really thinks. Often it's very wrong. When you do research on what the public thinks about sentencing, other than the broad question, is sentencing, this is the Goldilocks question asked around the world, is sentencing too harsh, just right, or too lenient? 80% of people will say it's too lenient because they have in mind some violent offence, a rape or an armed robbery or a murder, and they have in mind the kinds of reports that Fred or Frida walks free or gets some ridiculously light sentence. When you look at studies such as Kate Warner and others have done in Tasmania, where they've worked with jurors who have sat in on cases and asked them what they think of the judge's sentence after they've heard the case, the vast majority agree with what the judge has done, and the closer they are to the facts of the case, the more information, the less punitive people become. And this research is continuing. So the actual fundamental premise upon which many penal policies are based, that is, that the public is intrinsically punitive, is a false one. There's a great belief that prison is a crime control mechanism, and therefore the answer to crime is to keep increasing the prison population, and this is in fact what's been happening. So suspended sentences will be abolished completely by September of this year. Home detention was abolished. We've got something called the gross violence offences, and we did a report on that, and that's a presumptive 4-year term for offences committed in circumstances of gross violence. I won't go into that, and that's aimed at a certain number of serious offences. And as mentioned by Nick this morning, a new system of baseline sentences have been introduced, which is a set of presumptive median sentences for about 5 serious offences, and the starting points for those are significantly higher than current sentencing practices, often about double. If you've read the newspapers in Victoria, you'll see that there's been a major division between the government and the judiciary, and I agree, yes. That's what the Chief Justice wanted to say about that particular policy, and the letter from the Chief Justice was in fact leaked to the media, which had in turn been leaked the particular policy. But it's out there and it will be passed by Parliament if it hasn't been already. I've been asked to say just a few words about parole, and this has been a major crisis, and the Jill Meagher case precipitated a major crisis in the parole system and has contributed significantly to the increasing prison numbers. So our prison numbers are not only due to the number of people coming through the front door, but it's the people who are not being released at the end of their sentence, and the people who are in fact coming back through tightening up of breaches of parole. So although we haven't got the figures, I can tell you just from experience elsewhere that prison numbers go up quite significantly when you close the door. And this is a result of the Callanan report. And I want to say a few words about that. The Jill Meagher case was a tragedy, but even before that case and the reaction, there had been a number of concerns about parole. The Herald Sun had run a story about 6 murders that had been committed by offenders on parole, and in fact the Sentencing Council was given a reference by the then Attorney General to review the parole system, which we did and released our report in 2002. And we said that there ought to be a change in the principles underlying parole, that the decision about whether to release a person on parole was whether there's an unacceptable risk to the community if the offender is released on parole. And we said the basic principle should be a determination whether the risk to the community would be greater if the offender were released from prison without supervision and support provided on parole than if we kept them in. So the question was not whether you released a person or not, because 95%, 98% will be released, but whether you're better off releasing them on supervision. There were a number of problems with the system. There was inadequate guidance to the Parole Board. There was a lack of due process. There was inadequate information sharing between the Parole Board, Police and Corrections. There was inadequate risk assessment. There was inadequate testing of material before the Parole Board, and a terrible underfunding of both the Parole Board itself, which was making about 10,000 decisions a year, and the resourcing of community correction officers who were doing the frontline work. There was also a report by world-renowned psychologists forensic psychologist Jim Ogloff, which looked at those particular murders, and he also found major flaws in the system. The Callanan report, which I must say I thought was an extremely flawed report in the way it was written empirically. I thought the arguments were extremely superficial. If it were an essay of mine in criminology, I won't say what mark I would give, but I'd ask for a rewrite. But basically, this report has formed the foundation for the current parole policies. And to summarise, it basically said it didn't believe in the value of parole at all. It didn't believe that the community was better off by releasing people on parole. It believed that prisoners are manipulative and we shouldn't believe them. It said, rather than releasing people, we should just take the risk of releasing them without supervision, but we're better off keeping them in because we're safer during that period that otherwise would have been on parole than releasing them without supervision. It recommended the replacement of a part-time chair with a full-time, which has happened, which is a good idea. It effectively recommended the replacement of all the members, and that's just about occurred. And it says parole is a privilege, not a right. We shouldn't have any procedural fairness, a continued exemption from the Charter of Human Rights and Responsibilities in terms of procedural justice. And it did recommend a shift to the onus for serious offenders to prove that they pose a negligible risk of reoffending. They need to prove a negative. They have to prove that they're no longer a risk. I think that one has got stuck in an interdepartmental committee somewhere because that would mean nobody would be released, and I think that was a bridge too far. The government has tightened up parole laws. Breach of parole is now an offence. You're brought back in on allegations straight away. Serious sex offenders now have double hurdles. You have to go through treatment programs, and the question is, if those programs aren't available, does that mean you won't be released at all or released when your term expires? I'm not going to go through all of the limitations of the Callanan approach, but we can see that what it meant was investing $130,000 a year for every year that a prison bed is occupied, and I would question whether that's the best use of our money, whether it's the best use of 700 million, 800 million, 900 million or $1 billion. If I could answer more questions on parole, but I won't have time to go through all of my criticisms. This is reflective, by the way, of what's occurring elsewhere. I suppose if we look on the bright side, we could be living in Queensland. They're completely out of control there. They've got no upper house. They've got a government with an 87-8 majority, something like that. You've known the bikie laws, the VLAD laws, the vicious lawless association laws, the idea of criminalising association, people under those laws to be locked up 23 hours a day and to wear a pink prison uniform, not to see daylights. Why pink should be discriminated against, I don't know. The attorney there tried to introduce a law which said that at the conclusion of a sentence for sex offenders, that if he decided they were a danger to the community, he, the Attorney General alone, the criterion being he thought that they were dangerous, they could be kept in indefinitely, possibly. Fortunately, the Court of Appeal knocked that out as unconstitutional. But the path that they're going down makes us at least a little relieved for what we're doing. Debbie may disagree, but I think they show us what's possible when law and order gets out of control. New South Wales has been embroiled in the one-punch law debate. Again, we can see the effects of emotion over any rationality in sentencing policy. A mandatory 8-year minimum prison term for anyone who kills someone with a single punch while drunk or on drugs. That's got through Parliament. There were recommendations for 6 other mandatory minima for non-fatal offences while people are intoxicated or on drugs, ranging from 5 to 4 to 3 years. They're stuck in the upper house, and Nick told me that they were defeated by 1 vote. So Australia is caught up in a penal populist binge that other countries, and I just come back from a number of weeks in the United States, where they've been on this path for 30 years. It's been the age of mass incarceration. Their prison population went from 200,000 inmates in 1973 to 2.2 million this year. 25% of the world's prisoners, but 5% of its population. That's working hard there. 1 in 100 adults in the US is in prison, of whom 60% are black or Hispanic. A week or two ago, the National Academies, which is a joint scientific academies report released, said it should reduce its rate of incarceration. Why? Because imprisonment has a significant fiscal burden on society, costs of outpaced budget increases for other services that we don't care about, like education, transport, social security. Spending on corrections is the third highest category in many states behind Medicaid and education. There's no evidence, they said, or little evidence that all that incarceration has significantly reduced the crime rate. No evidence about the deterrent effects, and no evidence of very lengthy sentences. And in the US, 30, 40, 50-year sentences are not unusual. All of the criminological evidence shows that the propensity and ability to commit crime reduces as you get older. So there's a flourishing branch of criminology, geriatric criminology, about the healthcare problems of ageing prisoners, and the cost of that is a major concern. So it's not even sensible in terms of crime prevention. And they also say that mass incarceration causes enormous disruption to the societies, to the communities to which those people are returned. Not to mention the effect on the children, the families of offenders, and I haven't got the figures for Australia, but there are tens of thousands of children who are affected by the imprisonment of their parents, and that can't be good for their social development or mental health. I was asked also to look at the changing laws for individuals. I won't have time to go into what I call the laws of attainder relating to Julian Knight, but I saw that Julian Knight wishes to challenge the law in the High Court because it's basically a law that names him specifically in the legislation. We haven't done that for hundreds of years, the idea of specifically naming people. It may pass muster constitutionally because it's not directed at the courts, it's actually directed at an executive body, the Parole Board. But the idea that we are singling out an individual for that kind of attention, I think is dangerous. But we're seeing it again. I've seen reports in Queensland where the Attorney General is interfering in individual cases of discretion, and more we see political interference in not only parole decisions but also DPP decisions. We've spent 40 years getting the politicians out of criminal law policies, both prosecution and parole. It's now creeping back in. So let me conclude by saying that we have to understand what's been happening in a cultural context. We have to understand that it's the cultural and political factors rather than objective crime rates that hold the key to understanding our responses to criminal behaviour and to imprisonment rates. Penal policies are not based solely or even largely, sadly, on the rational empirical evidence about what works and what doesn't. It's deeply emotive. Crime is deeply emotive. It's the affective rather than the effective nature of crime control policies that I think rule penal policy. So as I've said, it's not crime rates, it's not demographics, it's not an existential crisis, it's not increasing income inequalities, although we're seeing those, and it's not neoliberalism or globalisation that explains our carceral explosion. Rather, they're driven by a discourse which is deeply rooted in the emotional and the symbolic. Michael Tonry, who's one of the world's leading experts on imprisonment rates and sentencing policy, put it nicely recently, and he observed in relation to federal and state imprisonment rates in the US, which I mentioned had gone to 2.2 million. And if I just change one word there, I think he got it right. He said, countries, and within Australia, I put the word Australia rather than the states in the United States, countries, and within Australia, Australian states have the policies and prison populations they choose to have. That is, the prison populations are not a natural outcome of crime rates, not a natural outcome of anything other than the political decisions we make as to the crime rates we have. So we have 800 per 100,000 in Northern Territory, we have a lower rate in Tasmania, we have a lower rate in Victoria. We're changing those because we choose to change them. And it's those differences in the local political environments which I think if you've got a grey beard like me, and I'm sorry, that's a gender-based statement there, you've lived through these cycles over, I've been watching this for 40 years, and we go through the Conservative and the Liberal and the left and the right over the decades, and we go in the cycle, the patterns of hope and promise, harsh reality, disillusionment, hope and promise, harsh reality, disillusionment, and so on. And we're going to go through this cycle, and I think we'll be there probably for the next 10 years in Australia. What's ironic is that nearly 4 years into the term of this government, the populist rewards of the punitive policies haven't actually materialised. If it's based on getting votes, a public opinion poll in November showed that since 2010, only 27% of the public thought that law and order and public safety had in fact improved. 41% thought it had stayed the same, and 29% thought it had got worse. And interestingly, in terms of importance, only 6% thought law and order was an important issue when deciding who to vote for, in comparison to 32% who thought that health and hospitals were important, 21% education, and 12% state finances. In fact, crime rates in some areas have increased in Victoria, not gone down, despite these measures. Much to do with family violence and our response to it, but in fact, crime rates in the short term have gone up. So, while we wait for the pendulum to swing back as it will, an excessive amount of public money will have been needlessly invested in prison infrastructure, in correctional personnel, and in court time in interpreting the new laws. That will inevitably go to the Court of Appeal and the High Court. Some crimes may have been prevented through incapacitating prisoners, but what it's clear to me is that it will be economists and politicians that will determine the future, not criminologists. And politicians will continue to make no apologies for what they're doing. Thank you.